Hello and welcome back to Module 9 when TUPE and redundancies overlap. Now, if you thought Module 8 was complicated on TUPE and dismissals, boy, you're in for a treat here. This is really technical. And I'm talking about, in the main, TUPE consultation and collective redundancy consultation and how they blend in and are separate and all the rest of it. Now, after a TUPE transfer, the transferee often ends up with two workforces that it needs to combine. And for this reason, an employer will often choose to rationalise and restructure the combined workforce to allow the business to flourish, and this might involve redundancies. Just by way of parenthesis, if you're carrying out redundancies, do have a look at my course at www.gettingredundancyright.com, which is a 10-module, 6.5-hour, very detailed course on making redundancies and how to do them lawfully, fairly, and minimising any legal risk and covering yourself in tribunals. There's a ton of resources there as well, ranging from template letters, model selection matrices, the transcripts, all sorts of things there to make it really, really easy for you to carry out the perfect redundancy process. But back to this, TUPE. TUPE transfers and collective redundancies have similar consultation requirements, but which are governed by different laws. So what happens when an employer ends up doing both at the same time? Let's look at the TUPE rules first. As I set out in an earlier module, an employer has to tell employee representatives about the transfer and the reasons for it. The employer's also got to provide information about any planned measures and consult on those measures with the aim of reaching agreement. The transferee has to tell the transferor about any measures they intend taking after the transfer for the transferor to pass on to the transferring employees. What about collective redundancy consultation rules? Well, they're found in a separate piece of legislation, the Trade Union and Labour Relations Consolidation Act 1992, known by its lovely pronounceable acronym TULRACA. And TULRACA contains the rules about consultation on collective redundancies. If an employer proposes to make 20 or more employees redundant within a 90-day period, it must consult appropriate employee representatives. Consultation has to begin in good time before redundancies take place, and if the employer proposes dismissing between 20 and 99 people, consultation has to start at least 30 days before the first dismissal takes effect. For 100 or more dismissals, the process has to start at least 45 days before the first dismissal. In the consultation process, employers have to give employee representatives information about which employees are being made redundant and why. They should provide details about selection methods and about any formulae for calculating contractual redundancy pay. Consultation has to include discussions about how to avoid redundancies, as well as reducing the number of redundancies and mitigating the consequences. As in TUPE consultation, the aim is for employer and employee representatives to reach agreement. In both TUPE and redundancy collective consultation, the process should take place either with a recognised trade union or with employee representatives. And again, in both, elections have to take place if there are no suitable existing representatives. That, as you may know, is subject to an exception for TUPE. There don't have to be elections if there are fewer than 10 people affected by the TUPE transfer. But if there are fewer than 10 people affected, the chances are there's not going to be collective redundancy consultation, because collective redundancy consultation requires over 20 people being dismissed. The sanctions are similar too. Under the Trade Union and Labour Relations Consolidation Act, it can cost an employer up to 90 days gross pay per employee for a failure to properly consult. Under TUPE, the penalty is up to 13 weeks gross pay. I think that's 92 days. I'm just going to check that on my phone. I probably should have done this before. 13 weeks times 7 days, 91 days. So it's a whole day's difference in the compensation. Both regimes have a special circumstances defence if an employer can show it wasn't reasonably practicable to comply with the rules, but they did everything they reasonably could. With both regimes, it's very difficult to win on the special circumstances defence. The information which needs to be provided under the two regimes is different. This reflects the fact that the two sets of rules deal, potentially at least, with very different circumstances. The rules also differ in relation to when the duty is triggered. In TUPE cases, the duty to inform arises when a TUPE transfer is planned. Consultation's triggered if an employee intends taking any measures. In redundancy cases, the rules require an employer to consult about ways to avoid redundancies. So consultation isn't always needed on TUPE, only if one's intending to take measures. It is always required in redundancy. Of course, if the two situations arise at the same time, and you're contemplating making more than 20 people redundant, that will be measures under TUPE, and there'll be an obligation to consult under TUPE. But does this mean an employer needs to start collective consultation before it's made the strategic business decision, such as a site closure, or only after that decision's been taken? Well, there's a lot of debate on this point in the courts. I've covered it in detail in Module 7 of www.gettingredundancyright.com. But for these purposes, the safest position for an employer is to assume that consultation starts before the strategic decision is taken. It should start when it's being considered or proposed. So careful planning is needed. Now, the redundancy timescales are pretty clear. Collective redundancy consultation has to start in good time and at least 30 or 45 days before the first dismissal, depending on the number of redundancies proposed. The situation in TUPE is a little more flexible. Information should be given to representatives long enough before the transfer to allow consultation to take place, and that's a bit woolly. The appropriate period will very much depend on what and how many measures are planned. The more measures planned, the greater the period required. The employer's got to think more carefully about when to kick-start the process. The overlap between the two sets of rules comes into play when a transferee proposes making 20 or more transfer-related redundancies within 90 days. As discussed a couple of modules ago, the duty to consult under TUPE is often limited. It's the transferee who's most likely to take any measures, and the transferor has no duty to consult with its employees about those measures before the transfer. The transferee has no duty to consult before the transfer, either because the transferring employees aren't the transferee's employees at that stage. Well, that's the reason. And because the TUPE rules only apply before a transfer, the transferee has no duty under TUPE to consult transferring employees about measures after the transfer, though it does have to comply with normal employment law rules after the transfer, including those relating to redundancy consultation. Now, despite what the rules say, despite what the TUPE rules say, the reality has always been different, as I explained earlier. Once a transferee said, we're going to make mass redundancies after the transfer, employees want more information. Representatives quite reasonably seek more details about the proposed redundancies and might be unwilling to wait till after the transfer for answers. And a transferee won't want to get its new employees or their representatives angry and offside at this early stage. Now, historically, there were a couple of ways that a buyer and seller could deal with this practical problem. Sometimes the transferor would make the redundancies before the transfer and deal with the consultation process themselves, or the parties would work together with the transferee collectively consulting with the transferor's employees. What about transferor redundancies? Dismissals which are by reason of the transfer are automatically unfair unless there's an economic, technical or organisational reason. Redundancy often forms part of an ETO reason, but the courts have said that a transferor cannot rely on a transferee's post-economic, technical or organisational reason. There may be circumstances where a transferor has its own ETO reason. So, for example, an insolvency situation where redundancies are needed to keep trading. But if the reason for the redundancies is essentially the transferees, the transferor can't rely on it. It can also be a bit tricky for a transferor to meet the ordinary rules for a fair dismissal in a transfer dismissal case, not least because the pool for redundancy selection might need to include transferee employees as well. Pre-transfer collective consultation informally has always been a common practice, but historically couldn't count towards a transferee's collective consultation obligations. So what happens is the transferor allows the transferee access to its employees, and both businesses inform and consult jointly under TUPE and TULRCA before the transfer. Sometimes they work together, sometimes the work is divided, with the transferor providing information to its employees and the transferee doing the consultation. That's probably more common, but the transferor has to make sure it knows in advance what the transferee is going to say to avoid any anticipatory breaches of contract. That might occur, for example, if the transferee tells employees they intend to make significant changes to terms and conditions after the transfer, which could entitle employees to resign and claim constructive dismissal against the transferor. But in 2014, new rules came in to address the anomaly between the rules in TULRCA and what was happening on the ground between buyer and seller. The government accepted that changing the rules would stop unnecessary duplication of work and reduce uncertainty for employees. So the process is entirely voluntary, and there are three conditions. Number one, a transfer has to be proposed. Number two, the transferee proposes 20 or more redundancies within 90 days at one establishment. And number three, at least one of the intended transferring employees may be affected by the proposed dismissals. So what happens? The transferee must tell the transferor that it intends to start consultation, and the transferor has to agree. This usually happens when the buyer and seller have a good working relationship and are confident the deal will happen quickly. It can also be more likely if there's no question of pooling the transferee's employees, I'll get that the right way around, the transferee's employees who already exist with the employees who are transferring over. So it's vital that the parties agree about what arrangements will apply in this process, ideally in a written agreement so everyone's clear. And who does the transferee consult with? Well, where the transferring employees have recognised a trade union, the transferee should consult that trade union. If the transferee's own employees may be affected by the dismissals, transferees should consult that union too. If there's no trade union, the transferee can choose one of two routes, either the existing transferor employee representatives or elect new representatives for this purpose. Now, the transferor can cooperate with this process by providing information and assistance to the transferee, but it doesn't have to. An uncooperative transferor won't give a transferee a special circumstances defence for any defect in collective consultation. And the situation can be avoided or minimised by proper discussion and agreement between the parties before the process begins. Now, at any time, the transferee can actually say, we're cancelling all that pre-transfer consultation. It might happen if the transferor is not cooperating and the process is stalling. And anything the transferee's done already won't count towards collective consultation. It won't stop transferor employees clamouring for information, so the decision shouldn't be taken lightly. And if the process is cancelled by the transferee, it can't be started again before the transfer. Consultation has to begin afresh after the transfer. What about dismissals? Although the transferee might be doing the consultation, any pre-transfer dismissals need to be made by the transferor, because the transferor is the employer pre-dismissal. And as mentioned before, pre-transfer dismissals might be automatically unfair if the reason for the dismissal is the transfer and not an economic, technical or organisational reason entailing changes in the workforce. It'll usually be really difficult for if not impossible, for the transferor to rely on the transferee's ETO reason. So liability for the dismissal, because it's automatically unfair, passes to the transferee. And due to the inherent risks associated with pre-transfer dismissals, what a lot of organisations do is enter into tripartite settlement agreements with employees they're proposing to dismiss to settle any potential unfair dismissal claims. So the agreement's tripartite, three parties, are between employee, transferor, and transferee. And the parties should also think about whether it's better to delay dismissals till after the transfer when the transferee's ETO reason has the potential to stick. So I just want to finish this module, which is quite complicated, by giving you some practical tips for pre-transfer consultation. Number 1, transferors should seek confidentiality agreements from the transferee relating to information gleaned pre-transfer via any consultation process. This normally forms part of the business sale process anyway. Number 2, it's always advisable to draw up a written agreement enshrining the arrangements for pre-transfer consultation and including how to deal with any costs associated with it and potential claims arising from it. Number 3, something I haven't mentioned before, employee liability information. Now, under TUPE, the transferor has to provide certain basic information about the transferring employees to the transferee, and it usually needs to be provided at least 28 days before the transfer. If the transferor doesn't do that, and I said it's fairly basic, it's actually quite wide-ranging. If the transferor doesn't do that and the transferee suffers losses as a result, for example, if there were claims that the transferor didn't tell the transferee about and the transferee took on responsibility for them, the transferee can sue the transferor in an employment tribunal for its losses with a minimum of £500 per affected employee. I've lost track, I think this is number 4. If pre-transfer consultation is cancelled by the transferee, if pre-transfer consultation is cancelled by the transferor's duties to inform and consult under TUPE still apply. The transferor needs to tell inform employees about the intended measures, the redundancies, but only needs to consult with employees if they intend to carry out those dismissals themselves before the transfer, because the transferor doesn't need to consult about what the transferee is going to do. Only inform, not consult. Complicated module. Thank you. You're nearly there. Well done. I will see you in module 10, which deals with harmonising terms and conditions. Bye-bye.